You might be from a different country, but you're living in the United States. Perhaps you're now a US citizen, or you're a green card holder, you're under some other visa. What kind of estate planning might you need? And what specific issues might arise in your planning? In this video, we're going to talk all about that. So I'm an estate planning attorney in California, and here in California, everybody needs, I think, a revocable living trust. If you have more than 184,000, about that much, then your estate can go through the probate process, which is horrible, all right? I actually did a video called 10 Things I Hate About Probate, all right? So we want to avoid probate if we can. So if you have any assets that don't have a beneficiary designation or they're not held in a trust, those could go through probate. So instead, in California, we always create a revocable living trust. So this holds your assets like any property that you own anywhere in the US, and also bank accounts, brokerage accounts, anything like that. Now you can have a revocable trust whether you're a US citizen or not a US citizen, right? But this holds your property here in California, and it can hold property in other states. But what about property in different countries? Perhaps let's say you're from India or you're from Ireland and you own property in those countries. Well, I'm sure the property is quite beautiful, but it cannot be transferred into your California revocable trust. The challenge here is that in other countries, they just don't recognize the US jurisdiction. Some countries don't recognize trusts at all, right? They have their own scheme for how things pass to the next generation. So what I usually suggest is that you talk to an attorney in that country, in India, in Ireland, in Nigeria, whatever country you're from. You talk to an attorney who specializes in estate planning in that country, and you prepare a will. And in the will, you say where you want your assets to go according to that country. Let me let you know, I've heard that I'm not an expert, by the way, but I've heard in France, you're limited as to where your assets can go. They're supposed to go to your kids. Here in the US, we can disinherit our kids or one of our kids if we don't get along with them or if they, for any reason at all. But I've heard that in France, you can't. So you really want to work with an attorney in that country to find out what can you do with property in that country. And then the will in that country will specify how things go. Now, you also want to talk to them if you have, for example, if you have a child with special needs and you're here in the US and you want to make sure that, your stuff in the other country can be distributed to the special needs trust for your child, talk to the attorney in that country to see maybe you could name the special needs trust as the beneficiary of the will, right? Things will pass into that trust upon your death. So a lot of times you can do that. Then if you do have property in another country, what I typically do when I'm doing an estate plan for someone who has property in that country is that in the will, I will carve out whatever's not in the US. All right, so I say that this will only controls assets here in the United States to make sure that the will is not used to try to control assets in other countries. And of course, that would apply to the revocable trust as well. Okay, so one big issue, if you're from a different country, you may not have a lot of trusted family members or friends here in the US. So you might want to name a family member or friend back from your home country, which totally makes sense. But unfortunately, that's disallowed. That's not beneficial here in the US. If you name someone who's not a US citizen as successor trustee, that can trigger some really negative tax rules. That trust will be called a foreign trust. And essentially, all capital gains taxes are due immediately. We do not want that. So you should not name a non-US citizen as successor trustee of your revocable trust, or really of any other trust that you set up here in the US. That's the main limitation, by the way. Okay, you can name non-US citizens for any other role, basically, for, inheriting assets, for your, agent for your healthcare directive or your power of attorney. Any of those are okay to name a non-US citizen, but not for that specific role of successor trustee. Also, if you have a trust where you're naming somebody as trust protector, I have a video on trust protectors. They're actually very good for an oversight. If you're naming a professional, for example, as successor trustee of your child's dynasty trust or special needs trust, and then you have a family member acting as the overseer or trust protector, you should not name a non-US citizen, because that can also trigger, unfortunately, those foreign trust laws. Okay, the other thing you should know relating to taxes is typically in the US, it's related to the marital deduction. So we have this estate tax exemption that says, at least now in 2023, you can protect up to, it's $12.92 million per person. And if you're a married couple on the first death, we don't even have to utilize that estate tax exemption, because everything goes to the surviving spouse free of estate taxes because of the marital deduction. Now, here's the thing. If the surviving spouse is not a US citizen, the marital deduction does not apply. You have a much lower number. So in those situations, married couples may set up something called a qualified domestic trust, a QDOT trust. Usually, you only need a QDOT trust when there's at least one non-US citizen in the couples who might be the surviving spouse. And usually you only need that if there could be some estate tax exposure. But you should talk with your estate planning attorney to see, do we need a structure where we incorporate a QDOT trust, QDOT, which is our cutesy way. We have acronyms for everything. So that our acronym for this type of trust is a QDOT trust. Okay, now remember I said that really anybody could inherit money from the US. That's true. In most states, when you inherit money, then the taxes are already paid. If there are any estate taxes, they're paid off the top by the estate. And then you inherit the money, you just say, thank you, thanks so much. Okay, there are a few states that impose inheritance tax, I understand, but not California. However, if you're in a different country, if your inheritors, if the beneficiaries are in a different country, that country might impose an inheritance tax. So you should look into that. Do you want the person inheriting the money to then have to pay a lot of money in taxes to deplete what they might have inherited? I don't know. That's something else to talk with the attorney in that country about, to see, is there an inheritance tax? How will this affect the person that I want to leave this gift to, that I want to leave a percentage of my estate to, who's in a different country? What will happen with that? So that's something you should look into to see if that might be an issue for the country or the countries where the beneficiaries might live. All right, now, what if you have a minor child? What if you're raising kids here in the US and you're worried, what happens if we're gone? Who's going to be the guardian? Now, the guardian, you can name a non-US citizen as the guardian. And when I say name, I actually mean you can nominate them. Whenever there's a guardianship proceeding, whenever both parents are gone, there will be a court hearing in the US to determine who's going to take care of the child now, who's going to be the guardian. So you can nominate somebody, but ultimately the court is going to decide. So if you say you have family in India and you want your parents in India to raise your children up until age 18 if something happens to you, you should spell that out in your will or in your guardianship nomination. You could say, I specifically allow my child to move to this foreign country and be raised there. Or perhaps you're going to say, you know what, I don't want my child to be moved to the foreign country. I want them to be raised here in the US, and therefore I'm nominating these other people, or I'm nominating friends. A lot of times as children get older, maybe they're already in high school, and it would be very disruptive to move them to another country. So you want them to stay here, and perhaps it's just a few years. Now, if you do name somebody as guardian in a different country, it might take them a while to get a visa to come over to the US, participate in the court hearing, and get your child and help them to move. So I often suggest naming temporary guardians. This would be a guardian who lives here. Maybe it's a trusted neighbor or a friend or a family member that lives in a different city that you wouldn't want to act as permanent guardian, but they could be named as temporary guardian. So they can take care of your kids until the permanent guardian can make it here to the US and help wrap things up. So I hope that this video clarified some things that you might face as you're doing your estate planning. So I encourage you now to watch this video over here where I talk about estate planning. What do all those terms mean? I talk about a lot of the words that we use in estate planning, which sometimes people can say kind of sounds like a foreign language, right? I provide definitions and what to expect. So please watch that video and I'll see you over there.